California
Recording in
Attorney General
progress.
here. Thank you for joining today. We're here today to announce a lawsuit challenging numerous federal agencies for conducting an illegal mass firing of federal probationary employees. The Trump administration's Office of Personnel Management's directive, that's OPM's directive to agencies to terminate probationary employees en masse to reduce the size of the federal workforce exceeds any statutory authority granted by Congress. Alongside many other actions the Trump administration has taken, this sweeping mass firing is simply put illegal. This action to quote unquote curb waste and inefficiency, end quote, is exactly the opposite. It's wasteful, it's inefficient. Unfortunately, this is yet another example of my office needing to follow through on our promise. We'll take action if and when Trump violates the law and infringes on our rights. Our lawsuit seeks to immediately halt further firings and reinstate unlawfully terminated federal employees while litigation proceeds. I, alongside 19 attorneys general, allege that the Trump administration's failure to comply with reduction in force procedures was arbitrary and unlawful. This mass firing is in violation of the Federal Administrative Procedures Act because the Trump administration proceeded with the terminations while ignoring critical protections that ensure workers and impacted communities receive advance notice of mass layoffs to soften the disruptions they cause and ensure that personnel such as military veterans are given preference in retaining their jobs. When a reduction in force results in a layoff of 50 or more employees, the agency must generally give at least 60 days advance notice to state governments so the state governments can provide vital rapid response information, resources, and services to affected workers. We've named many federal agencies in our lawsuit, including the Departments of Agriculture, Commerce, Defense, Education, Energy, Health and Human Services, Homeland Security, Housing and Urban Development, Interior, Labor, Transportation, Treasury, and Veteran Affairs. We've also named the Consumer Financial Protection Bureau, Environmental Protection Agency, Federal Deposit Insurance Corporation, General Services Administration, National Archives and Records Administration, Office of Personnel Management, and the Small Business Association, as well as the United States Agency for International Development, for all named for failing to provide any advance notice to California, causing significant expense and burden on our state. As a result of the Trump administration's callous actions, we're seeking the following remedies from the court: declaratory relief, a temporary restraining order to pause further mass firings and reinstate unlawfully terminated federal employees, and preliminary and permanent injunctive relief to enjoin further terminations, to stop and block further terminations that do not follow required legal procedures. The president has once again overstepped his authority by a mile, and we, again, will hold him accountable. Right here in California, federal employees heavily contribute to our economy by paying state income taxes and generating substantial local revenue. This reckless action has already caused a 149% increase in state unemployment benefit claims by federal workers. Undoubtedly, this will impact small businesses and decrease consumer demand. Countless people will no longer have the steady income to buy groceries, fill up their gas tanks, and support their families. It would appear that the president is committed to breaking the law and breaking his promises, including that he'd, quote, immediately bring prices down starting on day one, end quote. We can't forget the real impact of the Trump administration's actions on individuals and families across the nation. I listed a lot of agencies earlier, so as you can imagine, the impact is monumental. It's vast. These mass firings impact people dedicating their careers to serving the public, mission-driven workers, something we should be inspiring more people to do, not less. My office is hearing firsthand from people impacted by this situation. One Californian we talked to loved his job, loved his job working for the Federal Emergency Management Agency, FEMA. When disasters like wildfires strike, he was responsible for ensuring local agencies are able to jump the line to purchase the vital supplies needed. This employee, who was abruptly terminated despite rave performance reviews, is now buying only the bare necessities until he figures out the next step. That's unfathomable, which is why we have laws to help prevent it. Laws that the president, unfortunately, decided to break. Let's let today's lawsuit be a reminder that I stand with our workers, I stand with you, I stand with California and Californians. As Attorney General, I'll continue to use the full force of the law and the full authority of this office to address injustice. That means I'll see the Trump administration in court again. We don't expect the president's barrage of unlawful, chaotic, and disruptive executive orders and actions to slow down, unfortunately, which means neither will our work ahead. Fortunately, I know we'll be able to weather the storm and push back when laws are broken because of the dedication and tenacity of the folks on our teams. Before I open it up for questions, I want to shout out the folks at DOJ who made today's action possible: Claudia Gardia, Sandra Anderson, Christina Bull-Arndt, Miranda Mason, Satoshi Yanai, and Evan Akron. Thank you, and now I will open it up to any questions that you might have.
If you would like to ask a question, you may do so by clicking on the raise hand icon at the bottom of your screen. You'll then be moved to the queue. I will call on you. Please make sure you state your publication when you ask your question. You can also use the Q&A feature at the bottom of the screen to ask questions as well. Again, click the raise hand icon at the bottom of your screen to ask a question. First question comes from William. William, you are now unmuted.
Hi, thank you so much for speaking with us here today. My name is William Alhado. I'm with the Sacramento Bee. I'm curious to ask if your office has any sense of how many California-based federal workers have been fired, and a little bit about their demographics. Is there a specific federal agency that they have been fired from, and where in the state they are based?
You know, that's all information that we would like to have and would be more likely to have if the Trump administration followed the law. That's the whole point. That's the point of the notice. That's the point of the reduction in force procedure, to give states 60 days notice to identify who is losing their job, where they are, where they live, help them get a new job, to prepare for the support that they will need, including unemployment insurance for a time, potentially, as well as job placement support. So that is one of the problems with this unlawful action, that knowing exactly who's harmed, where they are, what they need, how they can be supported. The notice is supposed to provide that, and that is exactly what the Trump administration failed to do. So having said that, we do have some lines of sight into who and where. As I mentioned, the requests and applications for unemployment insurance are up 149 some percent. We think that this affects hundreds and potentially thousands of workers across the state of California, across the many departments and agencies that I've listed. And the harm to California is in the millions and tens of millions of dollars. But the level of specificity that you are asking about is something that we are seeking as well, and that the whole point of the existing reduction in force law is supposed to allow us to know. But the federal administration is preventing us from knowing that, at least at this time, because of their unlawful conduct.
Any other questions? Hearing none. Oh, William has another question. William, you're now unmuted.
Sorry, thanks. I figured I'll ask another one here. Referring to that 149 percent uptick in unemployment insurance claims, um, is there, can you give us a sense about like how many more actually unemployment insurance claims that is relative to, February 2024?
I think the number of claims is around 1,600. And so there's someone who could do the math on that. If that's a 149% increase, then there's a raw number that represents the the number of claims that are more in February 2025 than in February 2024. But this is just a snapshot. And again, there's people who have had notice of terminations who have not filed their unemployment insurance claim. We'd like to know who they are, so we can prepare. So it's imperfect information, but we do make the 149% comment around the increase just to make it clear that there are spikes in the request for unemployment insurance. That's a harm to us. That's a harm to California. But it is not representative, unfortunately, of all of the people who have been fired in California. Some may not ever seek unemployment insurance. Some may be waiting for some reason or just haven't got around to it. So that's, again, what the federal administration should have told us through the RIF, the reduction in force procedures. So we have a good sense of the whole universe of impacted Californians, the ones who are losing their jobs, the ones who will need services from California, um, including unemployment insurance, but also, we're going to have to brace for lower California tax revenue since they won't have income to be taxed and they won't be spending their money in the California economy, not to mention the impact on the federal agencies and departments in California that have less workforce and are impacted because of that and less able to provide the services and deliver the results for the people of California that they are, they have traditionally provided. So multiple impacts on California, but again, no perfect line of sight because of the federal administration's failure to follow the laws that would give us more information um, consistent with what you're asking.
Next question comes from Bob. Bob, you are now unmuted.
Might be talking on mute.
Bob?
I don't hear you, Bob. Sorry. Maybe it's a technical thing on our end, or I don't know if there's an unmute possibility on your side. I see you as unmuted on my end.
Okay. Hopefully he can still hear. I actually have his question. Why are AG Bonta and his colleagues suing once again over an issue that's already being challenged in another lawsuit now in San Francisco? The judge there has already issued a TRO against further dismissals and has another hearing scheduled for Monday. Isn't the issue being addressed adequately already without the need for another court action?
Thanks, Bob. I'll first say that in multiple actions taken by the federal administration that are unlawful and or unconstitutional, we've seen multiple impacted plaintiffs bring cases, and that's appropriate. Anyone who is injured by an unlawful action, an unconstitutional action, should consider bringing a lawsuit to remedy their harms. And our states have independent standing, a different type of harm than the worker plaintiffs and union plaintiffs in the San Francisco case that you've referenced. There are certain requirements owed and duties owed to the states, which is a foundation of our lawsuit, the 60 days notice if there's going to be a reduction in force. That's a way for us to implement our rapid response protocols and brace for the impact in California and help those workers. So that's not, that's a different duty owed us, a different claim that we have that's unique to us. I think it's appropriate for both lawsuits to be brought. Who knows the future of the San Francisco lawsuit? Will it continue? Will it not? Will it seek and realize and secure all the remedies it's seeking, or will it not? I think it's appropriate for states and unions, both of whom, and workers, all of whom have been harmed by this unlawful action, to bring their lawsuits. And the lawsuits are a little different, so let me get into the weeds a little bit. The Judge Alsop TRO is limited to about 6 agencies, since plaintiffs were establishing harm as vis-a-vis those 6 agencies. As you heard from my very long list of departments and agencies, we are bringing a lawsuit against many more defendants than 6 agencies. That their lawsuit in San Francisco is also focused on OPM and OPM's actions and directive to the departments and agencies. We, in our lawsuit, are focused specifically on the departments and agencies themselves, less so on OPM. And so those are some of the differences, but we have independent standing, we have unique and independent harm and injury, and so it's appropriate for us to bring our lawsuit, and also appropriate for the workers and unions to bring theirs in San Francisco.
I think that's it on questions.
Thanks for joining us, everyone. Appreciate you being here.